Welcome to Work Life Law with attorney Kate Cerrone. On this episode, the legal considerations for buying a fixer-upper. What are the most critical legal documents buyers should review before purchasing a fixer-upper, and how do they differ from a typical home purchase?
The first question I would ask is the zoning issues. So, if you're going to expand the footprint of the house, I would want to look into the setback lines of the lot, make sure that you can expand the footprint the way that you are planning. I would also look into the building codes to make sure that you get the proper permits in place for the type of work that you want to do. So, generally, if you are going to be changing plumbing, HVAC systems, any sort of things like that around the house, you really need to get the building permit in place. And you may be a contractor that already knows how to do this work, which is why you're in the market for the fixer-upper. You will be already be familiar with pulling the necessary permits. But the average person right now who's not even a contractor is possibly in the market for a fixer-upper right now. And the reason for that is that housing prices are high. So the houses that may have been in your range 10 years ago are no longer in your range because all of the prices are currently inflated. So it's better to look at a smaller house that you may want to expand. So if that is the case, then you need to look at zoning. Will the zoning allow you to expand the house the way you would like to? And the other, and another zoning consideration is that there are what we call non-conforming lots, which means a house that was built prior to the zoning regulations. And that means that the house may not follow the setback lines and rules or size requirements of a particular zone, but that's allowed because the house was there prior to zoning. However, you're not going to be able to change that footprint. So it may be fine the way that it is, but as soon as you go in and try to expand the size, you're going to run into a zoning problem.
Can you walk us through the legal implications of buying a property as is versus one with standard seller disclosures?
When you're buying a fixer-upper, most often the seller will sell it to you as is. And that means that both parties are well aware that the house may not even be in a livable condition and that they're selling the property as is. Now, what that means is that you are taking that property in the condition that you are viewing it, and you really can't complain about it afterwards. If there's some structural repair that you didn't anticipate, but you bought the property as is, then there's really nothing that the seller's going to be able to do for you after the sale. Unlike a sale where you're not taking it as is, there are some disclosures that the seller will be making to you. For example, that there's no flooding problem on or in the basement. So if that disclosure has been made, then you haven't purchased the property as is, then there are legal implications for the seller.
What legal protections do buyers have during the inspection period for fixer-uppers, and how can they use contingencies to their advantage?
So there are nuances to an as-is sale, however. You can ask for inspections, even though it's an as-is property, because you don't have to go in blind. You can still put in what we call an inspection contingency, so that if your inspector finds black mold behind a wall, you want to have the right to walk away from that purchase. So as is doesn't mean that you're stuck with any possible problem that you may encounter. You can still have an inspection contingency. There are still disclosure requirements that the seller has to make. It's just they're making those disclosures with the understanding that you are taking the property despite the problems that may be disclosed, but it doesn't excuse the seller from providing the disclosures that are required under Connecticut law. Any sale will come with these required disclosures. Then if the sale is as is, the buyer can waive contingencies. When a property is being offered as is, the required disclosures are always made. And then the buyer can decide whether they want to put in an offer either waiving inspections or still requiring inspections. So if there's competitive bidding going on for a particular property, you may want to make your offer a little more attractive and waive those inspections. And because then the seller can close sooner, and the seller doesn't have to worry that something's going to come up in an inspection that will make you, the buyer, walk away from the possible deal. So it's really dependent on the property that you are examining. If you're concerned that there are expensive possible repairs that you don't want to commit to, then you should put in an inspection contingency, which, even though the sale is as is, it still gives you the right to walk away from the sale, from the purchase. But if the house looks like it's in good shape and you have the expertise to make that determination, and it may be a house that's in a competitive area and there are a lot of offers coming in because the work required may not be a heavy lift, and there may be an opportunity to actually sell this at a nice profit. You might want to waive those inspections, but you do so at your own peril if then later you do find a very expensive repair that you were not counting on.
If buyers plan to flip the property, what legal considerations should they address from the moment of purchase?
So buyers that are planning to flip the property and they will not be using it for their residence, this is a commercial purchase. So if they are receiving lending, they have to be aware that the interest rates for commercial purchases tend to be a little higher than when you're purchasing your residence. So that should be something that they take into account. Also, there are capital gains taxes that are paid on a commercial investment property. So those are two aspects that make flipping a property different in the transaction than when you're buying your residence. And also, when you are buying a true fixer-upper and you are getting financing for that, the most straightforward financing will be if you are living in the property while you are fixing it up. If there's a period of time where it's not going to be inhabited, you really need to work with the bank to make them understand that you are fixing up this property in order for it to be your primary residence, so that you can still get that residential loan. But it's always good to be very upfront with your loan officer about that. Explain to them the work that may be necessary, that your intention is to live there, and see, what the bank can do for you as far as income.
When should buyers walk away from a fixer-upper deal due to legal complications?
So some red flags that buyers may encounter when they're looking at fixer-uppers. Some of them are the same as any other property. So if there is a particular property that's been on the market a long time, you want to probably ask some more questions about why it's been on the market that long. That may be an indication that other offers before you have come and gone because there's some sort of fundamental problem with the property itself. That would definitely be something you would want to be wary of. When a property is listed and there has been inspections, you have the right to know what the result of those inspections were. So definitely ask those questions if any prior offers have involved inspections. When a property is listed and the seller will only sell as is with a complete waiver of all inspections, that is a red flag. That would probably tell me that there may be something wrong with the property that a walkthrough will not uncover. So that would definitely be something to be aware of. That being said, overall, I would say that judging the property is a very personal decision, and that some people can find a lot of potential in a property that other people have walked away from. There are general rules to follow, like as I mentioned, the length of time property's been on the market, but it doesn't mean that may not be the right property for you. So the best course of action is to get the best possible realtor that you can find when it comes to flipping and fixing up, because this is an investment for you that is more complex than the investment in purchasing a turnkey house. So you really want some experienced professionals that will be there to evaluate for you, who are aware of the usual sellers, who know these red flags, and then your attorney that will handle the closing as well should be experienced and know what advice you will need when it comes to a fixer-upper.
How important is title insurance when buying a property that may have been neglected? And what specific title issues should buyers watch for?
So a foreclosure sale may be a good opportunity for a fixer-upper or flipping a house. Generally, the houses that go to auction are worn. They haven't been maintained in many years. There may be issues with the septic and the furnace and, anything, the roof, for example. And I would caution a typical buyer when they are purchasing at auction because there are no opportunities to inspect the property. Generally, what happens is that either the taxes have not been paid or the mortgage has not been paid on this property. So the lender or the town, in the case of taxes being past due, will set an auction date. And in a bank foreclosure, it's generally a Saturday. Those sales start at 10 a.m. You are allowed to walk around the property from 10 to 12. And that's the only time that you have access to the property. And very often you do not have access to the inside at all because very often the person who's being foreclosed has not given the bank access. And sometimes they're still living there at the time. And then in that 2 hours of evaluation, you decide whether you want to take on this house as a fixer-upper. I would say of all the foreclosure sales I've seen, 98% of them need a lot of contractor work in order to then be saleable at a later time. So generally, it's very experienced contractors that come to the auction sales. So they have done their research best they can. So they look at the age of the actual structure. The building department records will tell them when permits have been pulled. So you may have a house that was built in 1960, but then in 1980 went through a major renovation, which you can see because those permits were pulled and then closed. There may be a house that they say has rather good bones because it was built well. The roof looks good. They can see maybe from building permits when the furnace was put in. So maybe a relatively new furnace, a roof that was put on 20 years ago, and basically good structure. That may be a property that a contractor will take on. And they generally walk around, they take a look at the things like the chimney, the gutters, the driveway access, and things like that to try to, but they're making the best educated decision that they can make as far as how expensive the repairs are going to be once they get inside that house. Now, the opening bid is generally set at the bank's debt. So it may be a attractive purchase if you can get a house that you can resell later in the 300,000s and you're getting that house for $108,000 because that happens to be the remaining debt. So it's definitely a judgment call of a good professional whether to purchase at an auction. And the other consideration for foreclosure sales is that you are taking that property subject to any other liens that have not been foreclosed by the bank. So if there are any liens that are prior in time to the bank's lien, you will take that property subject to those liens. So that is something that you should look into carefully and proceed with caution. So if you are going to bid at an auction sale, you may want to hire an attorney to do a title search for you ahead of time so that they can tell from a title search what prior liens there may be on the property. So when you purchase a house in a foreclosure auction, there are no property disclosures at all. So really an auction is a true as is purchase. So there are no warnings, there are no disclosures. You are making this evaluation resources if there are structural problems that no one disclosed or liens that no one disclosed. There's just no responsibility on a foreclosing entity like a bank to make any of those disclosures. So a title search can be straightforward if there were only a few owners in the past and clearly there were liens that were released. So if you have two prior owners, each owner had a mortgage, the mortgages were released, and you can see that on the land records, that's a straightforward title search that can take maybe half an hour to 45 minutes. When there are many past owners with tax liens that you have to go back to make sure that they were properly released, or multiple mortgages, then that title search can take hours. So you go back 40 years is the standard for title. So a title searcher will go back in the land records 40 years to make sure that there are no unreleased liens.
What's your best advice for buyers who want to purchase a fixer-upper but feel overwhelmed by the legal complexities?
So when you are possibly buying your very first fixer-upper, my advice would be to avoid any kind of impulse buy. So sometimes you are seeing all the possibilities that this house could be a beautiful place to either live in or to resell, but proceed with caution, take your time. Don't jump at a purchase, especially when the seller is anxious to move it along and is not giving you time to evaluate this property. Really take your time, and you want to divide it up into categories that you could possibly talk to your attorney about, such as zoning, such as required building permits for the work that you see may be necessary, working with your real estate agent to see if you should waive the contingencies of an inspection or not. Take your time. And even if there are other offers and you feel that a great property might slip through your fingers, let it go if you don't have enough time to evaluate it. I think the work that you do before you put the offer in is what is going to save you time, save you money, save you aggravation later. An impulse purchase will only work out well by luck alone, and you don't want to be in that situation. So have your professional team at the ready as far as your real estate agent. Bring your attorney in early because your attorney can evaluate the zoning issues. And also, if you're not a contractor yourself, consult with the contractor that you would eventually hire. Line them up ahead of time because you are going to need a lot of time from them. Make sure that they have the schedule available for you, and let them be part of the process early as well so that you can evaluate how much work will actually need to be done. When it comes to a purchase of a fixer-upper, the old adage of buyer beware is prevalent in the deal because you may be waiving your inspections. You will most likely be buying this property as is. You may get into more of a project than you had anticipated, and you made that purchase. And there will be no way to undo that purchase later. So proceed with caution, take your time, consult with any possible experts you can think of to bring in. Don't do it alone. Don't do it on impulse. And it can really work out well.
The information presented is not intended to be legal advice. You should consult an attorney for advice regarding your individual situation.